My last question is relates to how things went down eventually with the trust and the problem which has come up over the fact that the letter that you sent a response, right? Now, they've said it was a grave impropriety. You have said it's a procedural lapse, and you've apologized for it. It's not as though you've done that as well. The issue, I think, is that the letter is sent on behalf of the Samiksha Trust as well, right? Because the letter which you'd sent to in response is not just on behalf of yourself personally, but it mentions
of the publisher, the Samiksha Trust,
and the other co-authors of the article as well.
Absolutely correct.
Was there, and this comes back to, for instance, were there any rules? Because I believe you are, as the editor, you are also, I think, an ex officio member of the board of the trust.
Correct. I'm a member secretary.
So
I was a member secretary.
So, on the basis of that, did you have the authority under the trust's own rules to be able to send this notice on behalf of the trust?
According to the chairman and the trustees, I didn't.
Right. But you feel that you did have the authority to send it on?
I did not consider this letter to be of such great importance.
Yeah.
I did look on it as a routine letter from a lawyer alleging defamation. And since all these letters have a standard format where the lawyer writes not just to the writers of the concerned article, but as I said, editor, printer, publisher.
Yeah.
Now in this case, our printer who prints physical copies is a separate entity altogether, unrelated to the Samiksha Trust of the Economic and Political Weekly. But in this case, it didn't matter because the print never had the printed version never happened.
Right.
So it was only the website.
Yeah.
Okay. So yes, I should have sought the prior approval and consent of the Samiksha Trust before engaging the services of a lawyer and replying to the legal notice served by the lawyer of the Adanis before putting all of this up in the public domain. Yes, to me, it is a procedural lapse.
Yeah.
To me, I did not commit a grave act of impropriety or breach of trust in ethics. Yeah. So I've said this to you before and I'm repeating myself.
Yeah. So because my last thing was just to close out on this, right? That I think the issue is that I think the narrative which perhaps you will see next week from the trust, that they felt that there were issues with the article, some of which are the ones which I have raised today with you. On that basis, they I think feel that even though there was no actual case, what you have here is a notice which is your response to the notice, because it wasn't specified to be without prejudice, and this is not your fault. So I think the lawyer should have noticed this, is that if you respond to even a letter before an actual case without saying it's without prejudice, that can then form part of the chain of evidence in any eventual case. And I think the danger is that, for instance, if any of the facts the trust, I think, felt that if they could rely, I'm speculating at this point in terms of why they call it an impropriety, is because if the facts turn out to be, if there's any situation where any of the facts turn out to be, they are able to find out is not credible or is not true, then they are bound by this letter in future correspondence as well. I think that's the concern. I think that's the reason why this has been elevated to.
So you're right. I appreciate their concern. I clearly failed to alleviate their concern. In my opinion, all such letters that to refute or accept. In my case, as of now, I repeat what I'm saying, I am more than reasonably confident that my facts are not wrong.
Yeah.